Court will enter a not guilty plea. I will set circuit court pretrial for
March 2nd at 1:30 with Judge Simpson.
March 2nd, 2026, 1:30 before Judge Hammoud. Yes, that's the bond.
Yes, Judge. I made this request last week as well. My client, unfortunately, he had a difficult time with his employment over the past 2 or 3 years. He was injured. However, he has been seeking employment. He actually does have a job offer letter substantiating that he's got a job waiting for him. Now that letter is from a company called Real Truck, indicating that his start date was actually supposed to be the day before yesterday, but he thinks that if he follows up with him, he might still be able to get this job underway, which is obviously significant because the whole crux of this case is to get some kind of payment schedule. If he's not working, then he can't work out a payment schedule with the prosecutor. So I understand that there's been some non-payment over the past year or so. That's because he has been unemployed, but now he actually does have employment. He's trying to properly put this matter behind him. So I think the fact that he actually does have a written job offer is good cause to reduce the bond. I would like a personal bond because that's all he can afford. The family is in court. There's no risk of flight. He's got 5 brothers and sisters. All of them have tried to talk and try to compile some, even the 25%. None of the family members can come up with this. So it's going to be up to Mr. Crawford to actually try to get payments to work something out ultimately when he deals with this felony child support case. So because he's got this job waiting for him, it's solid, it's confirmed, it's in writing. I would just ask that the bond be reduced to a personal bond, and let's deal with the matter at circuit court.
Are you saying the 25,000 that was listed on the complaint was only non-payment for a year?
Yes.
Is that what you're indicating, counsel?
Your Honor, I didn't do all the math on it. I think his support was set at about $1,200 or $1,500 a month.
Yes.
And I'm not sure if it was for 1 year. I think it was over a period of 2 years, or maybe a year and a half or so.
I mean, the difficulty is that the statute, I mean, I hear your argument, but the statute very clearly dictates 25%. I'm not sure that a job offer, and this court wouldn't find that a job offer in and of itself is going to constitute good cause, but
well, the only otherwise than what you're doing, then you're looking at punishing him for basically what he's actually charged with.
I'm not punishing him. He didn't pay for his child, so don't put it on me.
Well, in effect,
if you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else. The legislature made the statute. It says 25%. I'm not punishing him for anything. If he doesn't meet the standard of good cause, he doesn't meet the standard of good cause, counsel. Do I have a response from the people?
Yes, Your Honor. I would agree with you. We would ask that you deny modification of the bond specifically to a PR bond. Again, as stated last week and as stated today, lack of payments, promise to pay, to me, in my opinion, is not good cause to modify the bond. While the defendant was out and free and not under, of course, not incarcerated, he had the opportunity to pay. The amount that accrued is now at $32,000, over $32,000, and that was over a few years. So we have no guarantee that just releasing him and him seeking a possible employment opportunity will guarantee payment. And for those reasons, Your Honor, we would ask that you deny modifying the bond today. Thank you.
This is nothing different than I heard the last time that he was here. And quite frankly, the court in it would be of rights to up his bond because the amount is now higher than it was in the complaint. But I'm not going to do that. I'm going to leave it where it is at this point. But I'm not going to find that there's any good cause. Once again, motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
We're also aware of the bond violation this morning.
Yes,
Hi.
John. Brandon Bird on behalf of Bryce Anderson on the case ending in 5330.
And Ms. Anderson, can you please state your name for the record?
Bryce Anderson.
And Your Honor, as to the PCCs on this matter, we would be asking for an adjournment. I have spoken with the prosecutor. He's looking for a mitigation on this, which I'm happy to draw up, but that will take a few weeks.
Here, Your Honor.
All right, so you want me to adjourn that and the bond violation, or? what?
Your Honor, after speaking with our client, it's my understanding that she is willing to plead guilty to the violation this morning. We do have an explanation.
Adjourn to probable cause conferences then will the 5th be enough time for you to get done what you need to get done, or do you need the 12th?
I would need the 12th, Your Honor.
Adjourn these to March 12th, 2026, 9
I'm gonna
a.m.
come meet with you so we can.
As to bond, I guess, the court having accepted her plea guilty to the violation.
Respectfully, Your Honor, our client wasn't able to get in the house in which she was living at the time. So her tether died. Am I correct?
Yeah.
Our understanding is that she has a roommate, Your Honor. Her roommate locked her out of the house. Her phone was in the house. Her tether died. She wasn't able to get back into the house and charge it. She does apologize to the court for the violation. She really had no way to do it. As to the mistest, Your Honor, again, she didn't have a phone at the time. She couldn't
Did she
call.
not have the charger, or
She did not have the charger that was in the home.
did she go to community corrections?
She did not, Your Honor. She had no way to get there, and she otherwise would have called them. However, her phone was in the house. Is that correct as well? Okay.
Well, what actions did she take to try to get it charged?
I just tried to get back into the house and I just tried to try to find it, try to have her give me the charger or throw it through the window or something, and she wouldn't let me in.
Where was
Whatsoever.
the house was located where?
It was the one on Packer. It was the apartments on Packer.
It's a pretty tumultuous relationship with the roommate, Your Honor.
Okay, I get that part of it, but I guess what I don't understand, if she's on Packard, why she didn't just walk over to community corrections?
I honestly didn't even know I could have just come over and just said like, hey, I didn't have the charger. I really just didn't know that. I rather was trying to get it.
Well, where is the charger now?
Still in the house.
So if I were to let you out, where would you? Well, first of all, you didn't appear was one of the things. Why didn't she appear for the hearing?
Your Honor,
The last hearing, the jail did say that my client wouldn't come out the cell. Now, after speaking with Miss Anderson, Your Honor, she's been very polite to me. She has been very polite, and I believe we're able to work together now to get some of those issues handled. That's one of the reasons why we're trying to put in this mitigation report for mental health issues. My client does suffer from mental health issues, Your Honor, but she understands that she has to show up to court. She understands where she doesn't want to be at this time.
Okay, when she's locked out, where was she then? I mean, when she was locked out, where was she?
I was on Packer.
what did you do when you were locked out of the house? You were still at the house?
No, I ended up going over to my godparents in-laws. Ended up going over there and staying over there for a minute, and then going back to my apartment every day trying to get into the apartment. And that's where I got arrested as.
Okay, so when you went to your godparents, did you ask them to give you a ride to community? I mean, I guess I'm not understanding.
I never thought to come up to community corrections because I have to call a number, right? You can't just come up. You have to call the number, and the number says your number or color, and then you come up. But without my phone, then without the charger, I just didn't do it. I never thought to just pop up and come up. I didn't think to do that. It just wasn't in my mind to do that. I get what you're saying, but I just really honestly didn't think to do it.
Your response?
No objection to a release for treatment, but I do have concerns for this defendant's own well-being. On the new case, the 26 is in that report, the defendant indicates she attempted to harm and kill herself using drugs. So I'm concerned that when you don't have testing and there's this prior history of an attempt to use those drugs to commit self-harm, we might not see this defendant again if released on her own without any sort of supervision. So I think release to treatment would be good and appropriate, but otherwise I would ask.
Would
that
you be
bond
okay with a release to treatment? Is that something you want us to?
Yeah. Right.
Okay. Your Honor, after speaking with my client, it's my understanding that she herself would be okay with the release to treatment. So I'm happy to submit an order to the court.
All right, so what I will do is
I can submit it on your case too.
I'm gonna continue her bond at the amount it's at.
I'll get that
They'll
done.
sign once it's presented to me in order to release to treatment.
I'll include you on the email.
I'll also adjourn the sentencing on the violation to the March 12th date. So I'm not gonna sentence her on that. I'm just gonna leave everything where it is. We'll get the order. If she can get released to treatment, that'd be great. I think that might be the best thing.
Okay, thank you very much, Your
Thank
Honor.
you.
Thank you.
Okay, I'll be in touch, okay?
All right, thank you.
Thank you, Mayor.
Sweetheart.
Mr. Johnson? Yeah. As recalls case people versus Avion Johnson. What are we doing?
Respectfully, Your Honor, I just got appointed to this matter. We're gonna ask for,
And you're not ready? No, go ahead. I'm sorry. My bad.
we're gonna ask for adjournment on this matter.
All right.
I'm gonna have to turn in my green sheet.
You don't have it?
I don't.
What have you been doing? Besides, never mind.
Don't do me
Probably-
like that. Don't do me like that.
Probable cause conference. I'll just adjourn it out in 2 weeks, let you get caught up and do that. Okay, Ms. German?
Gotcha.
March 5th, 2026, 90.
And permission to address bond, Your Honor.
Yes.
Respectfully, my client did have she did drop dirty. She doesn't want to make any excuses why, but she wants to move forward and knows that she can move forward. 61 years old, been through a lot in her life, but she is trying to make things right. She has a Stop the Gun Violence Outreach Program that she's preparing for in June that's sponsored by the Ypsilanti, sponsored by the city of Ypsilanti, in which she's the administrator for and makes a lot of things happen for that. She understands that she needs to work at it. She does have meds that she's not receiving right now. She does have a therapist that she goes to when she's out that for some mental conditions that she suffers from. And she did put in a referral for Down Farms and mental health, in which she told me that
For Don Farms
the
and
outpatient-
mental health too.
No,
Go ahead.
okay. The Washington mental people gave me an intake.
For Don Farms.
Yes, sir, for the outpatients on Gulfside.
So respectfully, Your Honor, we're just asking that this wise and honorable court give Ms. Germa, give Ms. Germa a chance. Now, give her
Never
a
called me
second.
wise nor honorable.
Wise.
But go ahead.
Give Ms. Germa a second opportunity, and she will prove to this court that she can abide all bond conditions.
Yes, sir.
Any response from the people?
Judge, I believe that you changed your bonds because of contingency use.
Yeah.
And what she's doing in the jail is admirable, and I think that she can get started in the process now.
What I'm gonna do, just listen to, I'm gonna deny your request. However, I will sign, if I have not, a release to treatment. Okay? What's wrong, Ms. Gerber?
This will be our 5th event,
I know.
and it's in honor of my nephew who was killed on Thanksgiving in 2021, and all gun violence families, survivors, and the
But
community.
hold it. Maybe you're not hearing what I'm saying.
Shut up. I'm gonna shut up.
No, you can talk to me. I don't have a problem with that. The release to treatment can, I'm not saying that it has to be inpatient treatment. I'm saying she can be, but she's gonna have to be released to treatment. It sounds to me like you started that process. So if we can get that all worked out, I'm not gonna have a problem with that because that's really what you need. And although you're trying your best, you can't do that on your own. That's just the reality. And you know that as well as I. Okay?
Okay.
So, counsel, if you get me a release to treatment order, I'll sign it.
All right, thank you. Thank you, Your Honor.
All right, and for her, it can be inpatient or outpatient treatment, but I want something structured around her before I'm even gonna consider releasing her for whatever reason.
All right, sounds good, Your Honor. Thank you.
Thank you. Court does call the case, People versus Mario Taylor. Apparently, yes.
Tanaji Carey, I can really, on behalf of Mr. Thamar Johnson, Mr. Johnson, state your name for the record.
Thamar Johnson.
Thamar.
Wow.
We're asking for an adjournment, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Okay, Your Honor, I apologize. Okay, there is a piece of evidence that we were still waiting for. I had spoken with my client previously. We said we were going to set for exam. Once I spoke with the prosecution today or yesterday, they informed me that they're still waiting on that. I wanted to adjourn. It's some DNA
So-
evidence. Yes,
Oh,
my client would
DNA.
like to, he wants to move forward with the preliminary examination even without it.
And for what we're going to reach out to the OIC and provide with the date when we're going to get that back. They said soon, and I don't know how to interpret that. They
Sure.
didn't.
I mean, I'll set it, but you understand, sir, that if it comes in, it's not gonna be the basis for an adjournment because we know that it's missing.
I mean, Your Honor, I've been waiting,
Yeah, I hear you. I wish DNA could be done faster. It just, there's some logistical reasons and others that it can't be done that quickly, but
You're okay.
no, I'm just saying, I just got out of the joint on the 23rd, on the 3rd of September. And they
say
did my
again,
DNA and all.
you got out,
Before I got out.
hang on. You got out when, the 3rd of September?
Yes.
Okay.
And before I get out, they swabbed me and they took my blood for DNA and put it on record. I don't know why it's taking so long.
But it's not his DNA, it's DNA
From the scene.
from the scene, right? So when they swabbed you, yeah, that has been done. It's a DNA from this scene. That's the problem.
That's what they're trying to. No. So what do you want to do? Do you want to wait or do you want to say?
I mean, I'll do whatever you want me to
He
do,
wants to
but
set it.
pardon?
He wants to set it, Judge.
Okay, I can do it two ways. So I can have it set. I could set it later out so you could see if it's gonna come in, because I don't know what soon means.
Neither. Left a message with Paul. Haven't heard anything.
So I have lots of good time.
I'll check. I'll check.
So what do you want me to do? You want me just to set it and hope for the best, or? I mean, I can,
I've been waiting.
one thing, right, but one thing I can do is I can go to the 5th, like we're planning. If it's not, then just remind me and I'll just kick it out to my next date, which would be the 24th, which would be right around that same time, just to see if this stuff gets in, because it may exonerate you. I guess that's part of the problem, so.
Oh, the 5th? I think we're fine with that, Judge.
We're doing it that way?
Yes, yes.
Okay, so I'll set it the 5th for probable cause conference. just remind me that of what I just said, that if it's not back then and you want it set, I'll just kick it to my date and we'll go from there. How's that sound? Fair enough?
Yeah.
Okay, thanks. Bond.
Fair enough.
Court calls the case, People versus Malik Asidi.
Yes, Your Honor.
Alex,